Welcome back to The Verdict, a podcast brought to you by MLMIC Insurance Company. As we celebrate our 50th anniversary, we continue to deliver clear insights on navigating the complex world of medical professional liability. Join us as we cut through the noise to bring you essential information, expert perspectives, and compelling discussions designed to help you protect your practice and your patients. Be sure to like and subscribe to our YouTube channel so you don't miss an episode. I'm your host, Tammie Smeltz. My guests today are Marc Craw, Senior Director of Government Affairs with MLMIC's General Counsel's Office, and Morris Auster, Senior Vice President of Legislative and Regulatory Affairs and Chief Legislative Counsel with the Medical Society of the State of New York. Good morning, guys, and welcome back to The Verdict. Now that the regular legislative session has concluded, I couldn't wait to talk to you about it. Before we get started, Mo, can you tell us a little bit about yourself and your role with the Medical Society of the State of New York?
Thank you, Tammie, and thank you for inviting me to be part of this today. And we really appreciate all the great partnership that MLMIC and MSNY have had over 5 decades and your continued support on any number of issues that we work on. But specifically, I oversee all of the operations of the Albany office, which most specifically includes our legislative advocacy to the governor, to the legislature, state agencies, but also overseeing a lot of our public health work as well too, overseeing grants that we receive from the state and the federal government to help train doctors on various emergency preparedness activities and immunizations, as well as a grant that we receive to help provide training for physicians and helping to treat their veteran patients. And so it's a lot of those activities that are incredibly important for making sure that physicians are aware of sort of the larger societal issues that confront them as practicing physicians. But specifically on the legislative front, while that encompasses certainly advocating directly with legislators in meetings and writing letters, it's also involving a lot of our coordinating and developing grassroots letters. Helping physicians in their contacts with the media across the state, including MSNY officers, but also county medical societies. When, say, the president of the Erie County Medical Society is going to get interviewed on a particular topic, to help them make sure that they have the information that they need to help make sure that they can fully convey the concerns for something or support for a particular piece of legislation. So I like to feel I'm kind of collating everyone's various great relationships, because oftentimes, while we may have good relationships with some legislators in Albany, we have doctors across the state who have fabulous relationships, or county medical society execs who have fabulous relationships with legislators, and more often than not, their connection to a legislator can be incredibly important in a success or failure of a particular issue. So I really try and help them be as effective as they can possibly be.
Thanks. And that sounds like a really busy role, and it's quite diverse too.
Yes, definitely. I mean, that's only a handful. That's only a subset of everything I work on with regard to MSNY. I always like to say I started as the dishwasher at MSNY, and I worked my way up from that point.
Great. Thanks for that, Mo. Now, Marc, can you tell us a little bit about your role with MLMIC Insurance Company and how you collaborate with Mo and MSNY on legislative issues?
Similar to Mo, I serve in a legislative and regulatory advocacy role with MLMIC. I'm currently Senior Director of Government Affairs, but I've been doing that role really since 2017 when I started at MLMIC. So as a result, that's one of my job duties and in my portfolio. Another part of my job, though, that I really enjoy as well, and I think it brings me a lot of good insight into then my legislative and regulatory advocacy, is I also assist the general counsel with inquiries and questions, and you know this well, Tammie, that come from various MLMIC departments for resolution and advice and counsel. So that's a vital part, and I find that really helps me then when I review legislation that could have an impact on MLMIC and an impact on our policyholders, many of whom are members of MSNY. And so it's very, very important that I collaborate with MSNY, and we have a wonderful collaborative relationship. Mo and I, frequently discuss matters, especially during the 6-month legislative session that, as you noted, just concluded, Tammie. And it's really a wonderful collaborative relationship because we, through our many years of working together and from Mo's deep knowledge of the legislative process and the regulatory process through his many years, it really works well in terms of we kind of have a sense of where we are and we can move forward together to advocate against legislation that could be harmful to our policyholders and also to advocate for some measures that might be positive.
And Mark really does an incredible, really helps me do what I do, because oftentimes I rely upon him to tell me what a particular bill does. And, we'll talk about it specifically, but there's certain bills like that third party defendant bill where I'm a lawyer, but I'm not a litigation. I've never been in a courtroom. So I kind of rely upon Mark to be able to tell me what this practically means from a physician standpoint, so we can kind of really distill it down to something that's a talking point that when I go in and talk to legislators, I can tell them what this practically is going to mean for the patient seeing the doctor. And that really is in incredibly large part due to the insight that Mark provides.
Great. Thanks. One of the things I love about having the two of you on the podcast is because you are such great friends, and I just love to hear you banter back and forth, and you have a wealth of knowledge, both of you, and it's just really enjoyable for me to see the two of you talk back and forth about what's going on in the legislature and like how MLMIC and MSNY are going to partner together to help our healthcare providers throughout the state, which is a mission and a passion of both entities, MSNY and MLMIC. We're going to start off talking about the GFA, the Grieving Families Act. We've heard this for quite a few years now, and I know it's a worry for everybody in New York State, not only healthcare providers, but the community as well. Mark, can you give us a brief overview of its history as well as its current status?
The wrongful death law has been around in New York State, some version or another, since the 1850s. Originally, it was meant to compensate breadwinners, essentially, who died through the negligence of some other party. A big example was railroads, because they were huge, obviously, in the 1800s. And you were getting these deaths, and you'd have, widows and children who didn't have their breadwinner, around anymore. So it always had a mission of making the family, the survivors of the person who died due to a wrongful action by a party, to compensate them for the economic loss. But it never had really much of a non-economic component. And we all know non-economic damages, pain and suffering, grief, anguish, loss of companionship, etc. Those items were never considered, not just by New York, but many states throughout the country, to be damages available in wrongful death actions. So flash forward, obviously times change. I do recall as a young staffer, my first session in 1997, the wrongful death, a version to expand damages to allow for some form of non-economic damages. I don't recall offhand exactly what was in that bill. I don't know if it was pain or suffering, which is in the current version, but it was some form of non-economic damages to be allowed. That bill was heavily debated in the Assembly. I worked then for the Assembly minority who fought hard against it. It did pass the Assembly, but it went nowhere in the state Senate. Now, the state Senate was controlled by another party, and that was a major factor. So we flash forward to 2019, 2020. Both houses are now controlled by the same party, and that was the party, candidly, that pushed in 1997 the Wrongful Death Act in that house. So in 2022, the bill finally gained momentum in both houses and passed each house. And it had this element of non-economic damages, grief or anguish, as well as adding loss of companionship. And these actuarially just explode liability costs for medical providers and for any medical defendant. And the estimate by a well-respected actuarial firm is could very likely lead to increased costs of up to 40% for medical liability premiums. And obviously that's a huge, huge number. So that's where the bill has been. It then working with MSNY, who did a phenomenal job. And I think Mo really hit the nail on the head talking about grassroots. I worked 10 years for an association, the New York Insurance Association, that had insurance company members. So I know a little about grassroots, much smaller than a huge membership organization like MSNY or like the independent agents and brokers. But those membership associations are phenomenal in terms of boots on the ground, putting out a message, advocacy, in this case, against the Grieving Families Act. Really letters to the editor in local papers, which really drives a lot of attention locally. And in the end of the day, I think largely due to MSNY's great efforts and the business community, as you alluded to, Tammie, really, it was very united front through a coalition that MSNY and MLMIC were happy to join and are still involved with. We were able to get a veto in 2022, got it in 2023, and got one last year. So it's been vetoed 3 straight years by the governor after passing both houses. And I would note, we've gotten a little more no votes in the legislature. The problem there is, candidly, it passed very overwhelmingly in 2022 because it was and Mo remembers this well, I'm sure, it was a late addition. We were trying to hold it, out, and then at the last minute, the Senate decided to pass it, and then the Assembly followed suit. So you get a lot of yes votes because it was, so fast and not really enough time to mount a truly, intensive months-long advocacy campaign. We always lobbied against it, but that again resulted in a passing. But we have been able to be very successful lobbying the executive, and the reason why is it just costs too much. It's too much for the healthcare system.
Thanks, Mark. And Mo, what are your thoughts on the bill? And if it gets passed, what type of support would MSNY provide its members?
Well, our hope is that it does not get signed. I feel like we're kind of in this Groundhog Day moment where once again we're doing the same thing again when it's been vetoed 3 times, and this year's version is exactly the same. I mean, they changed. There's a new number, but it's but it's the same bill as there has been that was vetoed last year and substantially similar to previous cycles. So our efforts towards this again will be similar to what we've done in the past because they've been successful. We've already set up a sample letter that helps physicians send their own letters to the governor. We'll have talking points for physicians to use to make phone calls. We'll develop template op-eds for various physicians to send to their own local outlets to help legitimize, because we find one of the most important things about getting things out into the media is it gives it a bit more credibility when the public sees what the impact is. But I think the governor's office is well aware of what the impact of this bill is, and they know that this is going to have a very deleterious effect on our healthcare system, with hundreds of millions of dollars of impact upon physicians and hospitals, maybe actually more than that. I think it's significant, maybe in the billions, but even like an over $200 million per year impact directly to the state of New York through the various public facilities, public hospital systems across the state, not to mention the various municipalities as well that will be forced to raise taxes to help pay for the explosion in awards that will take place as a result of this. So, and those problems were before we even got to the passage of this reconciliation bill, whatever you want to call it, the big beautiful bill, the big ugly bill, which I've heard. And I think from a healthcare standpoint, it's really pretty big. It's pretty ugly, but I mean, there are some minor positive aspects to it, but that's really a peripheral issue. But for the state of New York, it's going to have a $750 million impact in the current fiscal year. This is the OBBB. And then future years, a $3 billion per fiscal year impact. So if the circumstances before were terrible for enacting this wrongful death expansion bill, it's even more problematic now. So I at this point, we're hopeful that these circumstances, by the time the governor considers the bill, that she'll be thinking about the same way. I can't imagine that she would think about it any differently than she has before, but you can never be too sure. And that's why we need to do our continued grassroots effort, because the circumstances that are now might not be the circumstances of the future. So you kind of have to continue to do that continuing buttressing of validating of our concerns and making sure the governor is aware of that.
Thanks, Mo. And if physicians or healthcare providers want to reach out to the governor, do you have documents on the website, on the MSNY website, or
Yes,
links?
we do. Yes, yes, we do. We'll have our letter that we sent to the governor, and we'll have our grassroots system that physicians can use, but we'll have a whole series of talking points that physicians can use for calling, for calling the governor's office.
Okay, great. Well, let's hope the governor vetoes it again this year. Fingers crossed on that. Okay, so Mo, can you provide an overview of the MSNY 2025 House of Delegates Resolution 65 of the Government Affairs and Legal Matters A Agenda, a New York Liability Commission? Can you tell us about that?
Yeah, it was a resolution sponsored by several doctors, I think several county medical societies, calling upon the governor to create a liability commission. I think their idea was, like I mentioned, made a joke before about Groundhog Day, but the concern that we're going to be doing this over and over again, and maybe we're going to hit a circumstance where there might be a different governor at some point, or there may be, or the circumstance that we have now is the legislature is very reluctant to override a veto from the governor. So we're fortunate in that sense that they haven't wanted to do that, but maybe there might be a circumstance in the future where they may. And in order to get out in front of it, the authors of the resolution thought it would be important for the governor to try and convene efforts among the various parties, bringing in the physician community, the hospital community, the business community, the lawyers, patient advocates, to come up with a comprehensive package that could be done where you do something to address some perceived deficiencies in the existing law for the existing wrongful death law, while at the same time enacting comprehensive medical liability reform to address some of the challenges. We didn't really talk, it's funny. I think we all take it for granted, but I realized we didn't even mention before how extraordinarily high liability premium costs are in the state of New York, for any number of reasons, but by far and away the highest liability costs in the country. And those costs, insurance costs, as a result of what's been approved by the Department of Financial Services, have gone up by 15%, roughly 15% in the last 4 years. So the cost is untenable. We need to find ways to bring it down. There are any number of steps that can be done in terms of limitations on non-economic awards, expert witness reforms, reducing the interest awardable in medical liability actions. That could also be packaged together to do something that may actually do something for everybody, and as a result, kind of take this issue off the table so we don't have to deal with it every single year. But that's a hard thing to get to, and sometimes what you need is a work group to come up where everyone can hold hands who are from disparate sides to say this is a package we think is for the benefit of New Yorkers. And that's what this resolution was calling for, asking the governor to create this liability commission. Now, I I think we just obviously have to tread carefully about how we approach that, because we have been successful so far. But I think the goal of that resolution was to think into the future and to try and forestall an adverse outcome that could occur in the future.
And I just want to add, I really commend MSNY and Mo and the entire team at MSNY for putting this forward. I think, as Mo said, it's a good idea for the future, and I know he and I and others in the healthcare system have really worked hard on some affirmative legislation that would reform medical liability, and we'll continue to do that. And I know MLMIC we're working on even more because we're so closely tied to it. We can assist MSNY and Haney's and Greater New York and other entities with ideas for how to have a more level playing field. Because as Mo said, it's ridiculous how much we pay as a state overall. The payouts for medical liability are almost double the next closest state, which is the second highest state in the union, and we're still well beyond it. We're more than California and Florida. I mean, it's not even
Combined.
Texas.
It's
Yeah,
combined. And actually, I think
yeah,
that was a stat that our president, Dr. Yakubovitz, had presented. And when we did our press release, we did our press release condemning the passage again for the fourth time. I was referencing a stat that I had seen where it was where, just stacking up that we were higher than Pennsylvania and higher than Florida and higher than California. He came up with a stat that actually showed that we were higher than California and Florida combined, and I had not seen that stat, and that actually took the New York Times reporter took note of that, and so that really just shows how out of whack we are.
agreed. Yep.
All right. Well, thanks, guys, for that. There was a lot of good information. Mark, the legislature passed two bills that would significantly increase liability for healthcare providers, hospitals, and medical groups. Could you talk about these two bills?
Sure. Thanks very much, Tammie. And I will first preface my remarks by saying these two bills that passed again favored the New York State Trial Lawyers Association. We seem to always be combating them in terms of their influence. And unfortunately, they put forward a lot of harmful legislation. These two bills are not nearly as detrimental to medical liability as the Grieving Families Act or Wrongful Death Expansion Bill, but it's like death by a thousand cuts, basically. So, and Mo knows this well. We see these bills at the end of session, they pop out. We do our best. We have memos in opposition lined up. MSNY does as well. We put it out. We advocate with members, but it's very hard to always succeed in advocating against these bills because, again, they just come out so fast. The first bill, fortunately, we obtained a veto working with MSNY, with Haney's, with all the medical stakeholders, is a bill that would allow direct recovery by a plaintiff who sues a defendant. The plaintiff could directly recover against what's called a third-party defendant. And this gets a little wonky, but in essence, the third-party defendant, I'll give an example in the medical context. Plaintiff sues a doctor for alleged negligence in performing medical services. Years go down the line, and then through discovery, the process, as we all know, in medical liability cases where you discover information regarding the incident, it turns out that there might be another doctor that shares some or even is fully responsible for the harm that occurred and the damages. But by then, the plaintiff can't sue that third party defendant who may have also caused some or all harm. And so the defendant, though, can bring them in because the defendant has a cause of action against them for money. But the duty is really owed by the third party defendant to the defendant, not the plaintiff. So this circumvents just basic fundamental New York tort law that's been around for hundreds of years. And it can result in the plaintiff even obtaining a little more money to the extent the argument made by the trial lawyers is that, well, if you have an insolvent defendant, it's really not fair. The plaintiff gets a judgment against them, but they really can't recover money. But the problem is that they might recover some money from the first party defendant, and then they recover a full amount from the third party defendant. That's a windfall for the plaintiff. So it's not a good bill. It would increase liability costs, is the bottom line. We opposed it and fortunately got a veto by then Governor Cuomo in 2019. We're cautiously optimistic. Usually a veto, even if it's by a different governor, will often be recognized for the reasons why they vetoed it by the subsequent governor. So we'll see. The second bill is even less of an impact, and it would have an impact not in negligence cases. So this is important to know, but in a doctor or a medical group committing an act that's considered a deceptive, unfair, or abusive consumer act, i.e. their patients. One example is of a case that I researched, and this is called the Unfair Deceptive Acts and Practices Law, UDAP as we commonly shorthand it. New York's law is viewed to not be as robust in consumer protection as the other 47 or so states. So one example is a physician was found guilty of liable of committing a deceptive act or practice when they charged an improper rate to a patient. So they charged a higher rate. So that's just gives you an example. So again, it's not they were negligent in performing medical services, but in their more position as a business, they committed an act deemed to be, insufficient. So again, it's death by a thousand cuts, but this bill would expand that legislation to make it even easier to recover against a business such as a doctor or a physician group. So.
Thanks, Mark. Mo, do you have anything to add to that?
That was a very comprehensive description from Mark, just that these are bills that we, for all the reasons we talked earlier about the very challenging circumstances that we live in New York, whether it is the high liability costs or where we've been regularly ranked by Wallet Hub as one of the worst states in the country to be a physician because of the high overhead costs, that we don't need one more thing that's going to make physicians not want to practice in New York State. And frankly, like I talked about before about the impact of the federal law, ultimately the ultimate outcome is you're also going to have a lot more patients that are going to be uninsured. And so your patients that currently have essential plan coverage, that Medicaid coverage, that 2 years from now may not have that. And therefore it's less revenue coming into the office to manage the processing of these cases. So we do not need one more thing that is going to make it more likely that physician's going to get sued or face higher liability costs or make it harder to pay their staff or invest in needed medical equipment to make sure their patients get the care they need.
Okay, thanks, Mo. Now, do either of you anticipate the legislature returning in the fall?
Well, it's an interesting
go ahead.
question.
Yep.
It's an interesting question because I think once the federal bill was passed, I think the immediate conclusion a lot of the lobbying community thought is, oh, they're definitely coming back. And then when the budget director made a comment about the impact, and obviously it is $750 million is a large impact for anybody, but in the context of New York for a $254 billion budget, it's not clear whether that is large enough to the point where they have to come back and do a mid-year budget adjustment. And so it remains to be seen. There was some provisions in the budget that gives the governor authority to do some kind of adjustments mid-year. So I don't know at this point. Mark may have more up-to-date information, but I've seen comments from legislative leaders saying that, including recently from the Senate Majority Leader saying, not sure if there's any reason to come back, and the Senate Finance Chair saying, I'm not sure there's any reason to come back. They may find some other reason to come back in the fall. So that remains to be seen. I also think they're continuing to assess the impact of the bill, and maybe circumstances are different 2 months from now. As of the moment, I don't think there's a definitive plan for them to come back to Albany.
Yeah, I totally agree, Mo. I would just add that, yeah, I've heard exactly what you've heard. And I get the sense, though, that, and you know how this goes, governors are usually reluctant to have a special session unless and until they really have to have one. Now, the legislature can go into special session without the governor, but they tend, again, the legislature's default position is we did our work during the regular session. We really don't want to go into a special session, during the off part of the year for them, unless we have to. And I agree with Mo. I think the budget director has indicated they think they can absorb the $750 million through various actions budgetary that the executive can take. They can always do that with certain amounts of money. Again, as Mo said, in a $254 billion budget, as much as all of us blanch at $750 million in the abstract, it's really not a large percentage of the entire budget. So I think the executive will try to deal with the current hit. And then in January, you see them really mobilized to handle, as Mo said, and I think it's a recurring cost, like Mo said, of $3 billion. That's getting real money, as we would say. But
yeah, and maybe you're going, I don't know if this was a future question, Tammie, but I think it does kind of hint to some of the real challenging things that we're going to have coming into the next year, where we've been able to, with a lot of different allies, like working closely with MLMIC and the hospitals, to defeat efforts to make physicians have to bear 50% of the cost of the excess medical malpractice insurance program. We've been able to stave that off for the many times it's been proposed in the past. Probably will come back again and again with a new budget hit, that we might have a harder time fighting it off. There's been a budget proposal, that impacts some certain physicians that want to be able to appeal if when they're out of network and working in a hospital context, want to be able to appeal to the state's independent dispute resolution system an underpayment by a Medicaid managed care plan. And the last couple of years, there have been budget proposals to try and eliminate that right and force the physician to accept whatever Medicaid will pay for that, which would be tremendously problematic for those physician practices, but also for the patients who need care from those physicians. That proposal will certainly come back next year in order to try and address this budget gap. And not to mention the fact that one of the items that was very important in the past budget was an increase in physician Medicaid fees. That was a almost certainly a direct result of this new taxing mechanism the state had for Medicaid managed care plans, that to drive up increases for across the healthcare system in Medicaid, that money's going to go away. And so there's a lot of consequences that we're going to begin to see roll out over the next year or so. But frankly, a lot of things that we're going to have to fight in the budget next year to address this budget gap.
Yeah, I would echo everything Mo said and just add from a really narrower lens of medical liability. As Mo well knows, there's two provisions in the state budget every year that do try to address and ameliorate the high costs of medical liability. One is the excess medical malpractice program that MLMIC is very pleased to offer to policyholders, including many MSNY members. So that's one that could suffer cuts and or restructuring that as a practical matter really cuts the program and could even destroy it. The second one is the medical indemnity fund that Governor Cuomo got through in 2011. People may recall that temporarily closed because it wasn't adequately funded. This year's budget increased the funding, but now, given, possible with the looming federal funding cuts and other measures that will harm the entire healthcare system, that program, I think, is very much up in the air starting in January, as Mo said, or to what extent they keep that program and perhaps close it to future enrollees, only, have current enrollees. You just don't know. But those are two discrete measures that really impact medical liability and help at least New York try to contain those costs. Those could be very much on the chopping block. So.
All right. Well, I think you guys have your work cut out for you next year. That's a lot to deal with. And I was going to ask about Section 18, but I didn't even think about the medical indemnity fund. And that is very important for us when we settle cases for brain damaged infants and the like. So that would be devastating for physicians throughout New York State. Just going back to the wrongful death bill for a moment before we say goodbye. Any idea when that will be delivered to the governor?
I don't think it's going to go to her until December. And the normal practice is, and Mose knows this very well, is that it's the governor's office that asks for bills to be delivered to her for her approval or veto. And I don't think they're in any mood to deal with it till near the end of the calendar year. But those are my thoughts.
Yeah, and that's what's happened the last 3 years, where it's either been around, like, either just before Christmas or after Christmas, depending upon whether they were going to let it carry over into the next year. So, I mean, things change. Like I said earlier, sometimes you get surprised by things and circumstances change. So, which is why we're certainly trying to get everybody to make their phone calls and send their letters now, because you just never know when the circumstances change. But that has been the circumstance. And it's not just the case for this bill, but like a lot of other bills that people view as being controversial, where they sort of hold it off. The bills that get sent now are like the renaming of the highway for the local official, or some where a tax law is going to expire at a certain time. Like, those are the ones that tend to get sent now, and they get progressively more controversial as the year goes on.
Okay. Well, I think we're going to have you on quite often next year because we're going to have a lot to talk about, I think, right? Thank you for making time to come on the podcast again with us today. We really enjoyed chatting with you. I know our listeners love hearing the legislative updates, and we appreciate everything you do for the healthcare providers throughout the state.
Thank you. And we are incredibly grateful for the support of MLMIC on a number of areas across a number of different activities that MSNY does. I mean, again, just from my own lobbying side, just for the insight that Mark can provide for what we do, but just from an overall MSNY side for the great support that you have provided to us in the medical community and physicians across the state of New York to help them continue to treat patients and continue to make New York a place that a destination location for patients to receive needed medical care.
Thanks, Tammie. I just want to echo what Mo just said. It's a terrific collaborative relationship. And here's the biggest statement for me is that Mo makes this arduous, unbelievably difficult process pleasurable. So it really is a great working relationship. And we even have a little fun occasionally. So
Thank you, Mark. I'm blushing.
no, I truly mean it, man.
Yeah, no, I can feel the energy between the two of you, and that's why I like to chat with you because it's really heartwarming. So thank you for all you do for us, and thank you for being friends with each other and making this a kind of difficult process have a little bit of shining light in it, right? So. And Mo, we were just talking about this earlier today. We've been with MSNY since the beginning of time, and it's our 50th year anniversary. So that just goes to show how much MSNY and MLMIC support each other. And I can't imagine what we would do without you guys.
And that's the verdict on the 2025 legislative session. To learn more about MLMIC, visit our website at mlmic.com or follow us on Facebook, LinkedIn, X, and Instagram. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable in your situation may vary or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, or professional obligations, the applicable state or federal laws, or other professional questions.